of hearings. And my intent is that if we can stay for our full allotted committee time until noon and conclude all the hearings by then our meeting tomorrow, Friday, is currently meeting on call of the chair, and we will not have to meet. The chair will not call the meeting if we can get through our hearings today. So we will try to do that as much as possible. And in the interest of efficiency and expediency, we are going to start first our hearing on Senate Bill 493, requiring ignition interlock device manufacturers to pay fees to the state for the administration of the ignition interlock program. And with that, a bill brief from the reviser, Ms. Moyer.
Thank you, Madam Chair. Good morning, members of the committee. Jenna Moyer, Revised Statutes Office, filling in for Jason today. Senate Bill 493, as the chair said, relates to the ignition interlock program, and it would amend KSA 8-1016, and that's the statute related to ignition interlock devices for use by individuals whose driving privileges have been restricted to driving with a vehicle equipped with such a device. The bill amends subsection C, which is on page 2 of the bill, and it requires the manufacturer of an ignition interlock device to pay the following fees to the Highway Patrol for the administration, oversight, and monitoring of the ignition interlock program. A one-time fee of $10 for each ignition interlock device installed by the manufacturer in this state on and after July 1, 2024, and that's counted and remitted on a monthly basis. A $5 fee for each device in use and maintained by the manufacturer in this state, again, counted, remitted on a monthly basis. And the monthly fee shall not be assessed or remitted if the device is installed for and used by a person who the division determines is eligible for reduced ignition interlock device program costs pursuant to subsection F. The bill also amends subsection C, and it would establish the IID fee program fund. And that is on page 2, and this fund shall be administered by the superintendent of the Highway Patrol. All monies received by the superintendent of the Highway Patrol pursuant to this subsection will be placed in this fee program fund and used only for the administration, oversight, and monitoring of the ignition interlock program. And the bill would take effect on and after publication of the statute book, which is July 1st.
Thank you. Committee, any questions? Not seeing any. Then want to let the audience know and conferees that we do have more than, we'll have about 12 conferees for our 4 bills we're hearing today. So gonna limit testimony, please, to 2 minutes on this bill, Senate Bill 493. I don't see any opponents testifying. So with that, then we will ask our proponent conferee, Matthew Payne, Lieutenant, Kansas Highway Patrol, to the podium. Please introduce yourself and welcome to committee.
My name is Matthew Payne with the Kansas Highway Patrol, and Madam Chair, thank you for the opportunity to speak and present this. I just want to first talk about kind of the changes that have been made. In January or July of 2023, the ignition interlock program went from a time-based to a compliance-based removal, which requires the bolstering and enhancement of the ignition interlock program because it's crucial for these people to successfully complete, these customers too. And in January 2022, the Highway Patrol was granted the authority and responsibility for this program. The ignition interlock program is a twofold program, one of which is vendor compliance. The other is customer compliance. And the vendor oversight program really regulates the manufacturers to ensure that they follow the regulated guidelines and rules and state laws and stay within those boundaries. It also ensures that those manufacturers report accurately and on time to KDOR, so these customers can successfully complete the program and get their regular driving privileges back. It also acts as a buffer between times when these customers have complaints that they've been mistreated or dealt with incorrectly, or these manufacturers at times have maybe not reported something to their satisfaction. This program also helps the customers in that and resolves disputes between the customers and the manufacturers. Just to give you an idea, there are over 300 service centers and 400 service technicians that currently one employee has to oversee to make sure that these manufacturers, these technicians, these devices are installed correctly, monitored correctly, reported correctly, and they fall within the rules and regulations. As far as the customer compliance goes, we have 3 troopers, and they make sure that these customers are trained correctly. They do public speaking to ensure that they understand how the device works and how to best use the device. It also does the compliance reviews in connection with KDOR to make sure that they've successfully completed the program. To give you an idea of what this entails, last year, the first year of the program, our customer compliance troopers did 4,538 customer reviews, which is about 18 per working day. Of that, 3,527 were deemed to be in compliance. 1,100 were deemed to be not in compliance. With that, 50 of those requested a secondary review and 11 were granted compliance. Now, when I say compliance, this is much more than just reading the report. These troopers do a fantastic job of actually investigating and making sure that these violations actually go to the right person. For instance, someone is driving their car that's not required that ignition interlock, and they miss a rolling retest, but we can't count that against the person who's supposed to have that restriction. So these troopers not just look at a piece of paper, but also have to go back, review video, review reports, review all the things that the ignition interlock records to make sure these violations are specifically addressed to the right and correct person.
Thank you, Lieutenant, for your testimony, and appreciate knowing what all the fees go towards. And I'll have you stand at ease for just a moment, if you would, and I'm going to ask, are there any other proponent conferees wishing to testify? I'm not seeing any. We do have your written testimony, and I thank you for that. I want to draw attention to committee documents and online. Other proponent written only testimony from Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. And are there any questions for the lieutenant? Not seeing any. You did a fantastic job then, right? No questions. So
thank you, Madam Chair, for your time.
Thank you, Lieutenant, for the work that you do. Are there any neutral or opponent conferees wishing to testify? Not seeing any, then we will close the hearing on Senate Bill 493 and open the hearing on Senate Bill 420, eliminating the element of concealment from the crime of breach of privacy related to installing or using a device to photograph or record another identifiable person. Under or through the clothing being worn by that other person or other identifiable person who is nude or in a state of undress. And with that, a bill brief from the reviser, Ms. Moyer.
Thank you, Madam Chair. Senate Bill 420 relates to the crime of a breach of privacy, and it amends KSA 216101. The current law, breach of privacy, requires several elements, and that would be knowing and without authority to install or use a concealed camcorder, motion picture camera, or other type of camera to secretly videotape or film another identifiable person under or through clothes for the purpose of seeing that person without their consent when there's a reasonable expectation of privacy. And this bill strikes 2 words so that it would be installing or using a camcorder or other type of camera. The concealment would be stricken. And then the other strike through is in line 33. So it would not be a requirement to secretly videotape someone. So it just strikes those words, concealed and secretly. And it would take effect on July 1, 2024.
Thank you. Committee questions for the reviser? Not seeing any. Thank you. We will limit proponent testimony to 2 minutes as well. I don't see that there's opponents signed up to testify, and we do have a full committee docket today. So with that, then we will invite proponent conferee Tim Leesman, Waubonsee County Attorney. Please introduce yourself and welcome to committee.
Thank you, Chair Warren, members of the committee. My name is Tim Leisman. I'm the Wabunsee County Attorney, here to ask you to remove two words from the 2160-101 statute, concealed and secretly. I just want you to imagine perhaps a drone outside of a window peering in while somebody's on their bed. Is that drone concealed? No. But is that an invasion of privacy? Of course it is. So removing these words are going to help advance us a little bit into the modern technological world. Also think about short-term rentals. Short-term rentals, often every room's got a bed in it, but there are lots of everyday objects now that have cameras that aren't necessarily concealed. They aren't obvious, but they're not concealed. So think about a remote workstation that's got a speaker video combo. That's not concealed, yet it's capable of being used for nefarious things. Now, we still have to prove intent in these situations, but we just want a little freedom and flexibility to cover some common sense things. I think in the past, to commit some of these voyeuristic acts, you essentially had to have a concealed camera, but now you just don't need to. Cameras can be very small, and again, I think there's this idea that you can have things that aren't obvious, but they're not concealed. And so that's what we want you to consider. Simply remove those two words and get us to cover situations that we're going to see more often in modern times. And that's all I have. I think I'm just under 2 minutes.
Perfect. Thank you. Appreciate it. Next, we will hear from Jan Jarman from the city of Wichita. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and committee. Thank you for having me. I'll be very brief. The situations we have in Wichita, detectives came to me and said, can't you do anything about this? We have victims in Wichita who are in stores and shopping and wearing a dress or a skirt. And we have people who are coming up behind them with cell phones and recording underneath their dress. We have many of these a year. And because the word concealed is in the statute, we can't currently charge them. Even though it's definitely a breach of privacy, these women definitely do not know that they're being videotaped at the time. We only find out after, when we can see on store video cameras what's actually happening. So on behalf of Wichita, we ask that you pass this on and support this amendment. Thank you.
Thank you. Appreciate that. And next, we will hear from Aaron Moses with the Wichita Police Department. Please identify yourself and welcome to committee.
Thank you, Chairperson Warren. My name is Lieutenant Aaron Moses. I am the Executive Officer with the Wichita Police Department. I appreciate the opportunity to testify on behalf of the Wichita Police Department regarding Senate Bill 420. The department strongly supports the proposed changes outlined in the bill. The current statute, KSA 21-6101, has proven effective in prosecuting cases involving concealed cameras. However, our investigators have encountered instances where the requirement for the camera to be concealed hindered the progress of the investigation. In May of 2023, our officers responded to an incident at a restaurant involving the inappropriate use of a cell phone by a male employee to photograph two coworkers under their skirts without their consent. The victims were two unsuspecting 20-year-old female employees. One victim did not know the photographs were taken until they were told by management later. The other victim was made aware by hearing a rumor from other coworkers. Despite gathering evidence, including surveillance video capturing the act, the case could not be prosecuted under KSA 21-6101 as the phone that used was not concealed. This specific case underscores the limitations of the existing law, leaving victims and law enforcement without options to hold suspects accountable for their actions. Our sex crimes investigators have identified several similar cases where victims are unable to hold suspects accountable due to the current language of Kansas law. To address these concerns, the Wichita Police Department strongly endorses amending KSA 21-6101 to include the act of photographing or videotaping a person in a state of undress without their permission, whether the camera was concealed or not. Thank you for considering the importance of this amendment and for allowing me to testify before this committee on behalf of the Wichita Police Department.
Thank you. Committee and the audience, there are proponent documents written only from Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence, as well as from Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Are there any other proponent conferees wishing to testify? Not seeing any. Are there any neutral or opponent conferees wishing to testify? Not seeing any, then I want to thank the proponents for bringing this bill forward and addressing some of the work that was done last year and looking at it in this bill. So with that, we will close the hearing on Senate Bill 420 and open the hearing on Senate Bill 473, authorizing a notice to appear that meets certain requirements to serve as a lawful complaint under the Kansas Code of Criminal Procedure. And with that, a bill brief from the reviser, Ms. Moyer.
Thank you again, Madam Chair. Senate Bill 473 changes elements in the Kansas Code of Criminal Procedure. The first one is in Section 1, amending KSA 22-2202. And that statute provides definitions for terms used in the Kansas Code of Criminal Procedure. Current law provides that a complaint means a written statement under oath of the essential facts constituting a crime, except that a citation or notice to appear issued by a law enforcement officer pursuant to and in compliance with KSA 82106, or a citation to notice and appear issued pursuant to and in compliance with 32-1049 would be deemed a valid complaint if signed by the law enforcement officer. The bill amends this provision to include that a notice to appear issued by a law enforcement officer pursuant to and in compliance with Section 2 of the bill for any unclassified misdemeanor or non-person misdemeanor would be classified a valid complaint if signed by the law enforcement officer and this would be on page 2 of the bill, and if there's a memorandum of agreement between that law enforcement agency that employs the officer and the county or district attorney in that jurisdiction where the notice to appear is issued. And 2, the notice to appear complies with the requirements of that memorandum of agreement and KSA 22-3102B, which outlines the requirements for prosecutions in the district court upon a complaint, indictment, or information. And Section 2 of the bill amends KSA 22-2408. This is on middle of page 3 in the bill. And this is requirements for a written notice to appear in court that could be served on a person by a law enforcement officer whenever an officer detains a person without a warrant for any act punishable as a misdemeanor and that person is not immediately taken before a magistrate for further proceedings. Current law requires that the person detained, in order to secure release, they have to give a written promise to appear in the court by signing the written notice prepared by the officer. The officer is then required to cause to be filed without unnecessary delay a complaint in the court where a person released is given notice to appear, charging the crime stated in such notice. The bill creates an exception to that complaint requirement if the notice to appear is a valid complaint pursuant to Section 1 of the bill, and the bill would take force and effect on July 1.
Thank you. Committee, questions for the reviser? I'm not seeing any. Before we hear from our proponent conferees, want to address Senate Bill 420 for just a minute, not seeking to reopen the hearing, but just want to make sure I didn't ask for any questions of the proponents from the members of the committee. So is it proper to, if there are questions at this time, we can reopen the hearing? Okay, so are there any questions for the proponents on Senate Bill 420 regarding eliminating the element of concealment of the video camera? So I'm not seeing any. So, okay, so just wanted to be thorough and make sure we didn't have any. With that, then we will invite proponent conferee on Senate Bill 473 to the podium. Ed Klump looks like he's ready to go. So Ed Klump with the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
There we go. Thank you, Madam Chair, committee members. Ed Klump and the associations, the chair listed, I won't repeat them. This bill was initiated by us, and we worked with the KCDA in developing the language that was presented to the reviser, who then worked the reviser magic to put it in the right words. And it is about efficiency. Today, what we're faced with in misdemeanor cases is, especially in the non-person misdemeanors, is that we take them into jail, we book them at the jail, and those people are usually bonded out on OR bonds and out of the jail quicker than the officers are. And so this is kind of trying to streamline the process a little bit, because this has taken, in some cases, a pretty significant amount of officers' time to transport these people to the jail. And then it takes a significant amount of time in the jail to get them booked and the paperwork processed and all that and bonded out. I'll tell you, this process that we're advocating for here is already in place in municipal courts for use by city police officers. And so it's not anything new to the system. It's a little bit of an expansion of what's available currently in the district courts. So what this bill will do in the way of efficiency is that time it takes to the officers. And the biggest time is driving to the jails. We have 11 counties now that do not have a jail. They contract with a neighboring county for their jail services. That's happening because of the shrinking population in our rural areas. And so we have officers who literally drive to the next county to book a person into jail, only to have them sign a bond and walk out the door. And we can do that same thing on the street through this process. They sign a promise to appear in court. The complaint part has the primary factors of the complaint. And what we do in this bill is we add some limits on that, which you see in items number 1 and 2 at the bottom of my testimony. The first one is it does not apply to person misdemeanors. We felt those were egregious misdemeanors that needed to have more attention to them by the prosecutors in the initial stages. And then also it wouldn't affect any of the various places where we are mandated to make an arrest, such as domestic violence and things like that. And then secondly, in order
You'll
for
have
this
to make it a quick second, please, Ed, because we're past the 2 minutes.
Oh,
But if you
okay.
could it is a complicated concept. So if you could just explain part 2.
Sure. Part 2, real quick. It requires an agreement between the district attorney and the law enforcement agency before it can be implemented. We did that because there's questions as to form that various prosecutors might want to address. And we want to assure that the proper procedures are there, that the more full information that's on an offense report reaches the prosecutors quickly in the right time frame. And that can all be addressed through a memorandum of understanding. And with that, I'll stand for questions. Thank you.
Thank you, Ed. And we'll hear from the other conferee before we open it up for questions. Greg Smith, Special Deputy Sheriff for Government Affairs, Johnson County Sheriff's Office. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm Greg Smith. I'm Special Deputy for Government Affairs with the Johnson County Sheriff's Office. We are very pleased that the association has brought this bill forward. We've been trying to get something like this passed for decades. The last time we tried was in 2021. It was HB 2389. Went through the committee process, sat below the line, and eventually died at the end of session. The simple explanation for this bill is this. As a deputy sheriff, I can make a stop inside of city limits, and if the city officer is there, he can write a ticket for certain offenses, and you get to go home. If I make the arrest, no matter what, or the stop, no matter what it is, I have to take you to jail. So this is a way, as Mr. Klump said, of streamlining the system. It allows a little bit more equity, whereas if you were charged with something in the city, you're not going to jail. But if you're charged by the county, you are going to jail. And it frees up resources and time for officers. And I'd be happy to stand for questions at the appropriate time.
Thank you. If you could stay right there, Greg, because I'll have a question, but open it up now for committee questions. Senator Steffen.
Thank you. Can you give me several examples of what kind of offenses would work under this, and what several examples of offenses that would not work under this change?
Yeah, sure. Say I make a traffic stop, and during that traffic stop, it turns out that there's simple possession of marijuana in the car. Normally, I would, as a county deputy, I have to take you to jail for that, but a city officer could write you a ticket and you could be released at the scene. Same thing for shoplifting. City officers could write a ticket for shoplifting, and I can't. I have to take you to jail. So there's a couple of examples.
How about examples that show me the other edge of this line? You know, what are the city folks having to take people to jail? Show me where their line is. I can see where your line is in comparison.
Just what I explained. They don't have to take you to jail for shoplifting. They don't have to take you to jail for simple possession of marijuana. They can write a citation, and that's the end of it.
So would the county sheriffs then be writing notice to appear for violations of city ordinances? Because a city is writing tickets for violation of city ordinances, and the sheriffs are writing citations for violation of statute. Do I have that correct?
But no, we're not writing for city ordinances. This just allows the NTA to be used as the criminal complaint, whereas now it can't be.
The criminal complaint for the violation of the state statute.
Correct.
Not the city ordinance.
Not the city ordinance, but the state statute.
Okay, so we're not going to have our county sheriffs enforcing municipal ordinances with this bill, correct?
That is not the case.
That's okay. That's correct, though. It's going to be state law and then municipal ordinances. Okay. Are there other questions? Not seeing any. Thank you for your testimony. Are there other proponent conferees wishing to testify? Do we have any neutral or opponent conferees wishing to testify? Not seeing any, then we will close the hearing on Senate Bill 473. And we will open the hearing and thank everyone for their indulgence who's here for Senate Bill 500. We'll open the hearing on Senate Bill 500, providing restricted driver's privileges for certain individuals that fail to comply with a citation and other elements of the bill. And with that, a bill brief from the reviser, Ms. Moyer.
All right. Thank you again, Madam Chair, hopefully for the last time today. Bill brief is for Senate Bill 500, and this provides restricted driving privileges for certain individuals who fail to comply with a citation, and would allow certain individuals with a revoked driver's license to be eligible for restricted driving privileges. Section 1 amends KSA 8286, and that's the statute related to habitual violators. Current law requires the division to revoke that person's driving privileges for a period of 3 years, except as allowed by KSA 8235. And this bill adds an exception for the restricted driving privileges authorized in Section 2 of the bill. Section 2 amends KSA 82110, and that statute is in the Uniform Act regulating traffic on highways related to failure to comply with a traffic citation. Current law defines a misdemeanor offense as either failure to appear before the court in response to a traffic citation and pay in full any fine and court costs imposed, or to otherwise fail to comply with a traffic citation as provided in KSA 82118. The bill amends subsection A1, and it would define the violation as a failure to appear before any district or municipal court in response to a traffic citation and pay any fine and court costs imposed as ordered by the court. A conforming change is made in subsection B1. Current law in B1 provides that when a person fails to comply and does not appear in court or pay all the fines, court costs, and penalties, the court notifies the Division of Vehicles to suspend that person's driving privileges. Upon receipt of that notice of a failure to comply, the Division of Vehicles is required to notify the violator and suspend their license until satisfactory evidence of compliance with the terms has been furnished to the court. The bill provides that the division is required to suspend the violator's license until that satisfactory evidence of substantial compliance with the terms of the traffic citation have been furnished to the informing court, unless the person is eligible for restricted driving privileges. If that person is eligible for restricted driving privileges, the Division of Vehicles shall notify the violator that the person's driving privileges are restricted pursuant to the terms set forth in subsection B1B. The bill also provides that the division shall terminate the restriction upon receipt of notification from the court that the person is in substantial compliance with the terms of the traffic citation. Subsection B1B provides that the person's driving privileges would be restricted to driving under only the following circumstance. These would be things like going to or returning from school or employment, returning from an employment with a healthcare provider, bringing your kids to or from school, and a person shall not qualify for those restricted driving privileges if you've been convicted of driving with a canceled, suspended, or revoked license more than 3 times, or if you're suspended for reasons other than failure to comply with a traffic citation at the time of that application. Restricted driving privileges would remain in effect for the lesser of 60 days from the date that the Division of Vehicles mails notice, or the person enters into an agreement with the court, or 3, the rescission of the restricted driving privileges by the Division of Vehicles. Subsection B1B also provides that the division shall rescind restricted driving privileges for any person authorized pursuant to this subparagraph if the person is found guilty of a violation resulting in a license suspension, revocation, or cancellation, or operating a motor vehicle in violation of restrictions 2 or more times. A person operating a motor vehicle in violation of these restrictions shall be guilty of operating a motor vehicle in violation of restrictions as provided in KSA 8-291. The bill adds a new subsection B2B to provide that a person whose driving privileges have been revoked solely for driving when the person's license was canceled, suspended, or revoked may submit to the Division of Vehicles a written request for restricted driving privileges. A person would not qualify for those privileges if they've been convicted of driving with a canceled, suspended, or revoked license more than 3 times, or suspended for reasons other than a failure to comply with a traffic citation at the time of application. Restricted driving privileges would remain in effect unless otherwise rescinded for the lesser of either the remainder of the period of time that the driving privileges are revoked or 3 years from the date when they were approved. The division would rescind restricted driving privileges if the person is found guilty of a violation resulting in a license suspension, revocation, or cancellation for reasons other than failure to comply with a traffic citation, and a person operating a motor vehicle in violation of these restrictions would be guilty of operating a vehicle in violation of those restrictions. A person's driving privileges would be restricted as provided in that subsection B1D to driving only under those certain circumstances, which I listed before. And the bill also adds a subsection C to remove a provision that requires the court to assess a reinstatement fee of $100 for each charge on which the person failed to make satisfaction regardless of the disposition of the charge for which the citation was originally issued. The district or municipal court would assess a reinstatement fee of $100 when the court notifies the division of a failure to comply with a traffic citation pursuant to subsection B. Current law in subsection E provides that a person who is assessed this reinstatement fee pursuant to subsection C may petition the court that assessed the fee at any time to waive payment of the fee, any additional charge imposed pursuant to subsection F or any portion thereof. The bill adds a new subsection E3 to require the clerk of the district court and the clerk of the municipal court to make forms available to a person seeking petition to waive or reduce traffic fines, court costs, or reinstatement fees. Almost done. A new subsection G provides that substantial compliance or substantially complied means that the person has followed orders of the court involving payment of fines, court costs, and any penalties, and has not failed substantially in making payments or satisfying the terms of the court order. And that's on the last page of the bill. And the bill would take effect on July 1st.
Thank you, Jenna. Appreciate that. Committee, are there any questions for the revisor? Yes, Senator Corson.
Thank you, Madam Chair. Quick question. How, if at all, does this bill impact those with revoked driver's license? Thank you, Madam Chair.
This would only relate to individuals with revoked driver's license because of this specific provision, because of the failure to essentially pay the court costs. And I believe the proponents can probably give a lot more detail. And also, there was a interim committee about this, and I believe Natalie has the report that gives a lot more detail. I think Vice Chair Wilborn was the chair of that. So this should have a lot more detail in the report.
Committee, before we entertain other questions for Jenna, we'll ask Ms. Nelson to pass out the special interim committee on driving privileges out to the members. Thank you. Are there other questions for the revisor? And I would, before we entertain that question, like for the proponents to address how this impacts revoked licenses. And yes, Senator Baumgardner.
Thank you, Madam Chair. Thank you, Jenna. So could you clarify, is a person's driving privileges or driver's license suspended due to non-payment of fines or court costs associated with a traffic citation in this bill?
Can you restate the question?
Sure. I'll put it a different way.
Okay.
With this bill, would a person's driving privileges or driver's license not be suspended due to non-payment of fines or court costs associated with a traffic citation?
So the word that the bill uses is revoked, which is, I believe it's different than suspended. And so I believe you'd still be eligible for your suspension of your license.
Okay. Could you explain the difference between revoked and suspended?
We're getting a little bit out of my area of expertise since this is more transportation law. So hopefully one of the proponents can go into more depth than that. I just hesitate to speak about something which I'm not certain.
I just hope that those that come and testify will make that abundantly clear, because there was a bill that was introduced, Senate Bill 440, that specifically addressed that issue. Thank you.
Thank you. Committee, other questions for the revisor? Not seeing any, then we do have 6 conferees on the bill, so we want to be respectful and allow everyone the opportunity to speak and time for questions at the end as well. And before we get started with our conferees, we'll comment from Senator Wilborn.
Thank you, Madam Chair. Thank you, Madam Chair, twice, once for allowing me to speak and secondly for hearing this bill. What I would like to do is very briefly go over the history of the interim committee. And I want to thank the good Senator Faust-Godot, who has been persistent and passionate about this subject along with others. She brought a bill. This bill is very similar to the bill that she brought to the Senate floor, but it had some technical problems. And I opposed the amendment in exchange for having an interim hearing. The people on the interim hearing were, I was the chair, of course. The vice chair was Fred Patton. We had 2 transportation chairs there, Mike Peterson and Shannon Francis. Of course, the research, Eric Adele, and revisers Adam Sievers were in attendance and gave great support for the 2-day interim hearing. We had much testimony from Driver Solutions, the Kansas Department of Revenue, Melissa Blaylock with the Judicial Administration, and of course, it was very important to have the input from Ed Klump and Legal Services to give us input to this bill. Everyone in this committee came out of the committee agreeing with the recommendations that went into the interim report. As you know, the interim committee has no legislative authority, but it was converted into Senate Bill 500. So with that, I have full support of the interim, which was last summer and last fall. And I thank everyone involved with the input, and we'll see from the proponents of what this bill does. Thank you, Madam Chair.
Thank you, Senator. And with that, then we're going to ask conferees to limit their testimony to 3 minutes, please, so we can stay on time and try to get out of here by noon is our goal. And with that, then we will invite to the podium Senator Aletha Faust-Godot. She's a Kansas senator from District 29. So please introduce yourself and welcome to committee.
Good morning, Madam Chair. Thank you so much, Senator Kelly Warren, for the opportunity to speak in support of Senate Bill 500. Vice Chair Wilborn is exactly right. I rise and stand in total support of Senate Bill 500 from the interim committee. and Senator Corson, ranking member, and the other members of this esteemed committee. Madam Chair, as you stated, and the Vice Chair, I've been a long time advocate to help those with suspended driver's licenses and with revoked driver's licenses, and particularly for those who have only violated a traffic citation by not being able to make that payment. It does state in there those habitual suspended drivers are not included in this particular piece of legislation. We already have a program within the Department of Revenue Driver Solutions to whereas those who qualify can get a suspended driver's license. However, to Senator Baumgartner's point, the bill that you spoke of dealt with revoked, and this bill does the same thing too. Madam Chair, those who drive on a suspended driver's license too many times, they then become, their licenses are revoked. And so over the years, those individuals who originally just for the, not a drunk driving, no other crime to it, just received a ticket and wasn't able to pay for it, and then the revoked status. And so this, Madam Chair, will help so many people be able to go to work, go to school, doctor's appointments, etc., and be self-sufficient and be able to provide for their families. I think this is a great step forward to helping those in this particular situation. And again, I just appreciate the work we did over the interim and the willingness of the chair to allow the hearing. Madam Chair, I urge the committee's strong support for Senate Bill 500, and I'll stand for questions at the appropriate time. Thank you, Madam Chair.
Thank you. And Senator, if you want to stay at the podium, you've waited patiently for the hearing to begin today. And so if you're ready for questions, we'll ask for any questions from the committee at this time. Not seeing any. Before you leave the podium, it looked like you were talking with a lot of members of the audience. If you have a short introduction to make, we would entertain that.
Madam Chair, I appreciate it. And today is Delta Day at the Capitol. The ladies in red, sorority sorors are here, and we will see them again later on the Senate floor. And to your staff person, Jenna, she said she didn't get the memo, but she's representing the Delta sororities in the audience. Thank you, Madam Chair.
Absolutely. Well, welcome to Senate Judiciary Committee, ladies, and welcome to the Capitol. We'll be seeing you a little bit later on the floor, so hope you enjoy your day here. It's good to see you. With that, then, we will invite our next proponent conferee, Lacey Black, Manager of KDOR Driver Solutions. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Lacey Black. I'm the manager of Driver Solutions. So Driver Solutions is within the Division of Vehicles, and we are the department that is responsible for receiving and processing the current restricted license applications, and we issue out the restricted privileges. So this bill would heavily impact our processing. I'm going to start off with answering a couple of the questions that were asked. So first, how this bill affects revoked drivers. It is very specific that it's a very specific group of people that this would allow restricted privileges for. So someone that is revoked for habitual violator, if they had 3 driving while suspended, only 3, they can't have more than 3, that put them on that 3-year habitual violator. And when they received those driving while suspended, they were only suspended on failure to comply. So they were not driving on a DUI suspension or no insurance suspension. They only had failure to comply. They got 3 driving while suspended. Now they're in a 3-year revocation. That's the group of drivers that now under this bill would be able to get the restricted privileges. So that was the first question. The next question was the difference between a suspended license and a revoked license. A suspended license, you can't drive. We take your privilege, KDOR suspends the privileges for an amount of time, waiting for the driver to either pay a fee or whatever the requirement may be. And then once that's complied with, they regain their privileges. A revoked driver, their privileges are completely terminated. So once that revocation ends, they have to go into the exam office and completely obtain a brand new license like it's their first time. They have to do full testing, pay all the fees, do the drive test, everything. So a revocation completely terminates their privileges. And then the other question I heard was about Senate Bill 440. It is my understanding that that bill is very much different than this one. That bill would prohibit the courts from even notifying the division if someone has a failure to pay. They would only notify us if someone fails to appear. With this bill, the way that I have understood it is the courts are still notifying us whether the person fails to pay or appear. We just group it in a failure to comply. The court's still notifying the division. And then at that point, the driver solutions staff would review the record, the driving record, and if they are otherwise eligible for the restricted license, they would immediately go on to a 60-day restriction in lieu of how it currently is, where we receive a failure to comply, we immediately suspend, and then it's up to the person to go and apply and get the 1-year restriction. So this would just take out that suspension period for someone who's otherwise eligible for it.
There will probably be questions, so if you'll remain here in the committee meeting room, that would be great.
Yes.
Thank you. Appreciate that. And we'll move on to the next conferee. However, just want to give everyone an opportunity to speak. Thank you. Next, we'll hear from Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please briefly introduce yourself and welcome to committee.
Ed Klump, 3 associations you just mentioned. We'll go from there. Thank you, Madam Chair, committee members. It's a pleasure to testify on this bill. This bill, I want to explain. We've worked with various legislators over the last 5 or 6 years on these issues, and we have come to the table trying to find resolution to some of the concerns that people have conveyed about this process of the suspensions. We think this is a very good solution. It maintains what is important to us, and that is a method to hold people accountable for their fines and for showing up in court. And this does it in a less intrusive way than is currently in there. So I just want to highlight 3 major things this thing does. Currently, the driver's license is suspended initially. And then we go into a great effort to get them to come in and apply for a restricted license. What this bill does, it initially puts them on a restriction and avoids that step altogether. That's important. That's a big step. It establishes a 60-day time frame for them to come into the court, appear, and get right with the court and establishing how they're going to take care of their fines. And as long as they do that, it remains restricted until they're in compliance, and then it goes away completely. If they fail to come into the 60 days and make any effort to appear and or to establish a relationship with the court, then it'll become suspended, but it's on their own actions that it becomes suspended. The second thing it does is having trouble reading my writing here. Substantial compliance. Right now, the law says full compliance, which means they have to pay all their fines, is the way some courts are interpreting it. This would allow, if they come in and they get up a payment plan and they're living up to that payment plan, then the court can lift this completely. And so that's another important key factor. Another one is we changed the word shall to may. The current law says the court shall notify the division. This says they may notify the division. That's a very important thing, because if the court has other tools they want to use, then they don't have to implement this if they don't want to. So it's up to the court whether they feel this is a necessary step or not. There's other things in this bill that I think are very important. This is a very good bill. It maintains what we need with really minimizing the imposition on the drivers. I will say one of the problems with revocation is that the way people become revoked under this, under current law, is they're suspended and then they drive while suspended, then they become revoked. But in this law, we clip that at the front end by keeping them on the restricted license. Then there is no violation of driving while suspended, they never become revoked because there's no suspension if they stay in compliance. Thank you, Madam Chair.
Thank you. Next, we will hear from Sheila Officer, Chair, Racial Profiling Advisory Board. Please introduce yourself and welcome to committee. Okay, we had her as testifying on WebEx, so we will circle back before we close the hearing. Next, we will hear from William Wilk with he's Senior Director of Government Affairs, Kansas Chamber. Please introduce yourself and welcome to committee.
Good afternoon, Madam Chair. William Wilk, Senior Director of Government Affairs with the Kansas Chamber of Commerce. You'll see on my written testimony that we were originally neutral, but I just want to thank the Chair for allowing us to flip to proponent here at the last second. So thank you. Working for the Chamber, we continue to hear from our members that access to a qualified workforce is their top concern. And in meetings on Senate Bill 500, what we want to make sure is that people who have a suspended license are able to go to work to earn the money to pay back their fines for non-violent crimes. Like I said, we have had conversations with the Vice President's office and stakeholders within this bill, and we want to work together to see if we could put some components from the list that was found from the interim committee hearing to see if we could add some of the non-violent crimes that will not lead to a suspension of a driver's license. So with that, I'm happy to stand for any questions at the appropriate time.
Thank you. And do we have Sheila Officer yet on WebEx? Is that her? No. Okay, well, we'll circle back before we close the hearing. Do we have any other proponent conferees wishing to testify? Yes, please introduce yourself and welcome to committee.
I'm WebEx Assistant. I'm here to assist you with your meetings.
And hold on, you'll have to turn on your microphone.
All right. Thank you, Madam Chair. I think testimony was turned in on behalf of Sedgwick County's Chair, Ryan Beatty. So apologize if it wasn't. We'll get it turned in. Sedgwick County just did want to be on the record as supportive of the bill. You've heard from Sedgwick County Commissioner Howell many times over the years about the large number of suspended licenses. It's actually a disproportionately large number of suspended licenses in the Sedgwick County area. And we would echo what the state chamber said. People do need to be held to account for the offenses. They need to pay their fines. We want them held accountable. But we also do see that people get into a cycle of owing large sums of money, and it's very hard to get caught up, be on the right track when you can't get to work. And that's the main reason that we support this bill. This would allow people to continue to work and pay their fines. So happy to stand for questions at the appropriate time. And again, if we did not get testimony in, we will. Thank you.
Thank you. Appreciate that. Committee, we do have proponent written only testimony from Faith Martin, Racial Profiling Citizens Advisory Board, Walt Chappell, former Vice Chair, Racial Profiling Advisory Board, and Greg Nickel, part-time municipal judge, full-time county administrator. And with that, then we'll open it up for questions. Are there any questions for our proponents? I have one for Mr. Watkins, since you were last. If you have any insight as to why this is a substantial problem for Sedgwick County, if you'll identify yourself again, please.
Yeah, Jason Watkins again for Sedgwick County. That question's been asked many times, and I don't know that we have a solid answer for that, Madam Chair. We are the largest city in the state of Kansas. I think there has been some thought over time about do our courts maybe respond to some of these situations differently than other court systems. I don't have that answer. It's been asked several times, and either way, I think this is a good step in the right direction to solving that problem.
Thank you. Committee, other questions? Senator Baumgartner.
Thank you, Madam Chair, and you can just walk right back to the mic. So talk to us a little bit about the fines, because it's a recurring problem, particularly in Sedgwick County. There's this notion of, from the chamber, well, if they can at least have a restricted and can go to work. But obviously, something's going on. We know that in other states and other communities outside of Kansas, they found that the fines, and I know there's this notion of we must hold people accountable. But that notion of folks that are low income unable to pay the fines. And so we are in this continuous cycle. So what are the fines and how do they ratchet up if it's a second offense on a restricted, a third offense? Talk to us about those fines.
Well, somewhat difficult for me to talk about the fines. Ed might be actually a better one to describe the different levels of fines.
I'm talking about in your community.
Yeah, I'm not an expert on what those level of fines are. I do know that there was talk about you get arrested for driving on a suspended license. That's just not a fine. They take you to jail for that. You know, and the fines do increase for repeat offenses. But I think you hit the nail on the head, Senator. If these people cannot get to work and they're low income, and while we're not here today to talk about public transportation, we do not have a great public transportation system in Wichita. That's not a criticism of my city. There's only so many resources, and a lot of the population doesn't support it. So if you're low income and you have a high amount of fines, and you don't have the ability to get to work, you're in a cycle that, frankly, I think it's almost impossible to get out of. And I think that's kind of to the point that you're bringing up.
It is. So we don't have any sense of what the cost might be.
I really don't. I think Ed might, because I think those are really pretty similar across our communities in Kansas.
I think it gets back to also, if you're low income, what are you going to spend your money on? Well, if you have children, you're probably going to spend money on food, diapers, whatever are the bare necessities. Probably not going to find a way to go and pay a court fine. Thank you, Madam
The
Chair.
lowest priority when it comes to feeding yourself, your children, and making sure that you can keep a roof over your head.
Thank you. Thank you, Madam Chair.
Thank you. Senator Olson.
Yeah, them are great points. And, you know, what's going on here? We get people in these cycles, once they get in the system and they can't get out, they get the fine, they can't pay the fine, you know, and then all of a sudden they're in this cycle for 3 or 4 years without a license. They can't feed themselves, they can't take care, and they might not even be low income. It's just they just don't have the right amount of income, and they've lost that job. They have no way to get to work. I think this bill's definitely a good step in the right direction, but the fines are something we got to really look at. Make sure every case is going to be a little different, and make sure we adapt. The counties adapt on these fines to be able to make sure there's a plan that's not the county's plan. It's the one they can meet because, you know, these people are struggling. But I'll tell you, their life will be a lot worse, and the taxpayers will pay more if we can't figure out ways to keep them to where they can keep their employment and their way of life. So I think this bill's a good step in the right direction, but the fines are very important.
Thank you. If we could have Ed Klump, if you have an ability to answer Senator Baumgartner's questions about the fines and fees that are involved in the first suspension, the second, the third, and if you could just talk about that for a minute.
Sure.
You want to introduce yourself real quick?
Yeah, sure.
Thank
Ed
you.
Klump with the Law Enforcement Association, Chiefs, Sheriffs, Peace Officers. So we put a provision into the law, I think it was last year, specifying that when a person has one of these restricted licenses, even though it was technically suspended and then the restrictions were allowed, that they would only be cited for driving on a restriction or driving in violation of the restriction. They would not be cited for driving while suspended. The citation for driving while suspended is where the real problems were created in people becoming revoked and the extended times and all that. Another provision in the bill is the current law. The fee to get it reinstated if it's suspended was $100 per charge that you were facing. And in this bill, it goes to $100 for the reinstatement period. It doesn't matter whether it's one charge or 100 charges, it's $100 fee, administrative fee for that reinstatement. That's another huge advantage. I don't know what the fines are specifically for driving while restricted, but they certainly don't carry a multiplier for multiple offenses that I'm aware of. So I don't think there's like a higher penalty for first, second, or third. And if I may, Madam Chair, I'd like to also address the fine issue. One of the things that this bill does that I mentioned that's very important is it allows for the courts to honor when that person comes into compliance with the court. That means if we set up a payment plan and they're making those payments, they're in compliance. If they show up in court and they make arrangements with the court, they're in compliance. And that's very important change in this. And remember that they can't come into compliance if they never come into the court. And that's the biggest problem here, is they never come into the court, so the court can work with them and look at what is your financial situation and how do we address that. My experience is the courts are very amenable to looking at that and reducing fines where it's appropriate because of a person's ability to pay. And so there's a big difference too between ability to pay, which is, I think, what Senator Baumgartner is really talking about here, over those that certainly can pay, they just refuse to. And we want to take care of those that don't have an ability to play or to pay. And we've had several issues besides this one where that's come into play with DUIs and some other things where we've really worked with getting some language that allows for that. Now, I found that even on a payment plan, if a person comes in and they are truly financially strapped, if they are on that payment plan and they come in and make 2 or 3 payments and they hit a hitch and they come back into the court, I've seen courts that just waive the rest of the fine because they came in and they made that effort. But the biggest thing is get them to come into the court so the court can work with them. I don't know. I hope that answers the question.
Thank you. Senator Baumgartner.
Thank you, Madam Chair. I think it's helpful, but I think the one thing that isn't helpful is it's inconsistent. You may happen to live someplace where the court will work with you, but it doesn't mean that you do live in a place where a court will work with you. And I think that when we're working on legislation, we need to be thinking as far as what are we doing across the board that is consistent, not just hoping that there will be grace in a particular area. One thing that hasn't been addressed is, so how much additional court time is this will the passage of this bill impose? Maybe not so much in the courtroom, but court staff. Has that been addressed at all?
I mean, I'm not an expert in the courts, but I don't see where it's going to negatively impact the court-on-court time because they don't do anything under this bill that they're not already doing. What they do is different. In other words, instead of notifying the motor vehicle department that there's been a suspension, they're notifying the division that there's been restrictions applied to the license. And so I just, from my perspective, I don't see where this adds any workload on the courts. It could actually reduce it if we can get people to come into court under this restriction and deal with the issues. We can then allow the courts to make that evaluation of financial ability to pay and make the appropriate arrangements. But I agree with you with consistency, but consistency doesn't mean everybody is treated exactly alike, but consistency means to me that the same considerations are given based on ability to pay and things. And I don't know how you legislate that because that falls into the parameter of court discretion. And I know I've heard a lot of discussions in legislative bill hearings on that, and it's a very difficult issue. And I think it's separate from what this issue is here.
Thank you. And I do see in the fiscal note that the Office of Judicial Administration states that enactment of the bill could have a fiscal effect on judicial branch operations because it could result in individuals filing motions seeking to waive or reduce outstanding fees, which could result in more time spent by court employees and judges processing and deciding fees. According to the office, a fiscal effect cannot be estimated until the judicial branch has had an opportunity to operate under the bill's provisions to see if people do file these motions or if they don't, or how much different the judicial branch has to operate if this bill were to become law. So thank you. And or if we have an audience member who can answer the question, but I think we've got the information in the fiscal note. And Senator Steffen has a question.
Thank you. I'll start with an observation. This is an area that doesn't fall on my radar screen at all. So I'm looking at it from a very different view than some of you guys probably are. But I'm a little troubled with the idea that you make bad decisions enough times that apparently at some point you become a victim. And so that makes me step back and want to reanalyze this, and maybe Senator Wilborn could help shed some light on it if he's willing. But if the real problem stems from the fact that somebody gets one ticket and it's so exorbitantly high that they can't afford it, well, is that not a better place to address it than moving the line in the sand back, saying, okay, you've made two bad decisions, so we're going to back up and let you make 4 bad decisions. I'm struggling with the concept of how we're helping people understand that their behavior doesn't fall in line with what's socially accepted. Can anybody help me understand why we're attacking it this way, then rather than saying, yeah, you give a $200 ticket to somebody who makes minimum wage, that's a lot of pain. You give me a $200 ticket and I'm PO'd. I'm not necessarily in pain. I'm PO'd. So, help me understand this. I need help understanding and not feeling like we've turned these bad decision makers into victims.
Is there a conferee wishing to answer? Thank you. Please introduce
Probably
yourself.
not. Yeah, Jason Watkins, Sedgwick County. Probably not, but I'm going to go ahead and try. I kind of feel like the senator at the end of his question made the point that we're making. If you have a low income person that gets a $200 ticket, that's tough. I've reached a point in my life where I'm like you now. I don't even know that the $200 ticket even POs me. I'm just like aggravated that I got stopped and that I'm having to spend my time dealing with this, but I can deal with the $200. I'm not even going to tell my wife. I can just pay it. But I remember a point in my life where $200 was a lot of money to me. And a long time ago, I got a ticket. Then got a ticket for not having insurance. And, fortunately I had a family that could help me out. And we got this figured out and I got on track. Now that's over 30 years ago, just so nobody looks down on me. But I remember being in that tough spot where that was going to be really hard to get out of. And so I think you answered it right there. Now, I don't think you can go create a system where you say we're going to make the fines proportionate to what somebody's income is. I mean, that would be an impossibility. You can't do it that way. And so I think that what we're looking at in this legislation is really your best opportunity to try to move forward and help people get out of a cycle. And I don't even want to call them victims. I agree with you, Senator. There needs to be responsibility. And if you break a traffic law, you need to be fined. But I think we've reached a point where for some of these people, if we don't let them go to work, they're never going to get out of this cycle. Whether we consider them victims or not, we need to figure out the best way forward for them and society in general. And I think this bill goes a long ways in that direction.
Thank you. And we certainly wouldn't want to create a two-tier system of justice where if you can afford the fines and fees, you're treated differently than if you can't. So, other questions? Not seeing any. Are there any other neutral conferees wishing to testify? And do we have Sheila Officer on WebEx? I'm understanding she's trying to join WebEx, but she's having technical difficulties on her end. Okay, so she's not on WebEx. Then we will hear, we do have neutral written only testimony from Noah Bain, Justice Action Network, and we will hear from our opponent conferee, Mike Fonkert, Deputy Director, Kansas Appleseed. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I am Mike Fonkert, Deputy Director, Kansas Appleseed. And thank you to all the members of the committee for allowing me to speak on this important matter. I rise in opposition to this bill today, not because I don't commend the efforts to address such a large problem in Kansas, but because any effort to address our suspended driver's license problem that does not end the failed policy of debt-based suspension, also known as failure to pay suspensions, is only a half measure. It is a Band-Aid at best, and it is over a gaping wound. You can look at the numbers in testimony. Our best number is 130,000 suspended Kansans only for failure to pay. Some cite numbers as high as 208,000. There are good pieces in this bill. We certainly commend collapsing the reinstatement fee and working to achieve a pathway for revoked status drivers to get some amount of driving privileges back. However, as I think we have learned here today, talking with proponents, this bill is quite complex and confusing. And honestly, I think it's working too hard to solve a problem that is easier to solve than what this bill does. I also believe this bill will impact a much smaller population than some would argue. When you listen to the individual from the Department of Revenue, it's a very specific subsect that she was talking about. Using driver's license suspensions for failure to pay tickets, traffic tickets, is a failed policy, plain and simple. It's an absolute failure. It is not a tool in anyone's tool belt. It does not work, as we can see in Kansas with hundreds of thousands of people suspended for failure to pay. This is not a situation where it does more harm than good. It literally does absolutely good. And I appreciate that there was an interim committee that worked for a couple days on this. I've worked for 5 years on this matter. Every state that has looked at this has found the same thing. It does not increase compliance, and it does not increase collections. It only traps people in a vicious cycle where they are branded criminals for not having enough money to pay, not for not making good decisions, for not having enough money to pay their tickets on time. The evidence is clear, and half of the country has already abandoned this practice. We are not unique. We are not special. We do not need to devise a complicated way to solve this problem. The answer is right in front of us. Though Kansas does have the 6th highest suspension rate in the country, the same thing is true here as everywhere else in this nation. Suspending for failure to pay doesn't work. It's a miserable failure. And when we recognize that a policy doesn't work, that it has failed so miserably, we must end it. We do not need to find a compromise with it or hold on to the belief that it works. It's clear that it doesn't. It needs to simply be abandoned. Anyone that equates this to being tough on crime totally misses the mark here. These are not criminals. They are people with not enough money to pay. If ending this practice means you're soft on crime, then I guess the lawmakers in Montana, in Idaho, Utah, New Mexico, Virginia, West Virginia, Mississippi, and Wyoming have all suddenly become soft on crime. That list goes on. We know that these states are not soft on crime, and they're just ahead of our state in realizing this policy is a failure in addressing it. I urge you to incorporate the language from Senate Bill 440 into this bill to dramatically improve it. Thank you, Chair.
Thank you. And you might stick near the podium in case there are any questions. Do we have any other opponent conferees wishing to testify? Not seeing any, then we'll open it up for any questions from the committee. Yes, Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Fonkert, for your testimony. Toward your last statement, I appreciate the passion with which you address this issue um, as an opponent, but I kind of appreciate this initial effort, at least, that is being offered in Senate Bill 500 and what we've heard from the conferees, without tweaking it too much, because there are a lot of stakeholders that have worked very diligently over many years to address this. What briefly, by way of improvement, appreciating the initial passion that you brought in your testimony, what very briefly could be done other than that cycle that no one's going to get out of that's been addressed, what briefly might be done?
Yeah, so I think the first thing is, suspending for failure to pay doesn't work. It doesn't work anywhere. We need to figure out how to stop that and shut off the faucet that is filling up this pool of suspended drivers. The best way to increase compliance is to actually find a way to reduce fines to a way that people can pay. Payment plan excess, and making that uniform. This bill says substantial compliance, but it's going to leave it up to each court to determine that. So it's going to be an inconsistent experience. If we want to wade into mandating, there's been legislation in the past that I've worked on, mandating a uniform payment plan for all courts to use that establishes a very low threshold based on income so that folks can get into compliance by making a small amount of payment. The best way to do that also incentivizes folks. As Mr. Klump mentioned, you make a series of payments and eventually the court gives you grace and forgives whatever's remaining because you've done, your due diligence. So those are two things that I would really highlight here. But when you look through this bill, there's some inconsistencies about who can apply, if they're revoked, if they've driven on a suspended for, more than 3 times. Again, the policy doesn't work. Evidence shows that over 75% of people that are suspended continue to drive because they're forced to. We have no option in this state not to drive, and people are put in the position to spend money they don't have or lose their jobs, not get their kids to work, not get their grandma to the doctor, so they drive. It is a total failure of a policy. And again, half the country has already abandoned this practice.
Thank you, Mike Fonkert. And Madam Chair, if I might, just a brief for either staff or for maybe Lacey Black. If we've maintained demographic information for those stops and where they've been made, we've heard that Wichita is a hot spot. No offense, but it is disproportionately so. But do we have some information from other parts of the state or jurisdictions that show those that are drastically or as drastically impacted from this systemic inequity other than Wichita?
It's not our practice to invite proponents back to the microphone once we've moved on to opponents, so we're going to stick with that. But if research has some of that information or the revisor does, and certainly the work of KDOR, if there's that information available, I'll ask that could we please have that distributed to the committee after our hearing today. Would that work for you, Senator? Thank you. And then I think Senator Olson has a question.
Yeah, kind of follows up on that. Can we see what the list of what other states are doing on this? I mean, I'm guessing we got a sheet somewhere.
And actually, yeah, some of this might be in the special interim committee report. Is that?
I don't know if you have the sheet that breaks the state by state down.
And if research could help put that information together, maybe with KDOR or some of the, maybe Mike Fonkert has some information. Go ahead, Mr. Fonkert.
Yeah, if you would permit me, I have a spreadsheet that shows what every state has done with regards to driver's license suspensions, and it's pretty clear. So I'd be happy to share that with.
I'd love that
with yourself and the committee.
Thank you. And if we could get that report from research as well, that would be helpful for the committee. Thank you. Committee, other questions? I'm not seeing any. Then thank you very much for your testimony. Committee, then I want to thank the conferees who have appeared today and for your testimony today and for the work of the Special Interim Committee on Restricted Driving Privileges. And that was a 2-day hearing, I think, 2-day hearing. I was not part of that special interim committee, but want to thank the work of the committee and those who testified in that committee as well. So with that, then we will close the hearing on Senate Bill 500 and want to commend the committee for their work and having us be concluded on time before noon. And thank you to the conferees for abiding by the time limits. Thank you to the audience for following along. And thank you to the staff as well for your work. With that committee, then, I do not anticipate calling a meeting tomorrow, Friday, but we will be meeting Monday to work bills and for one hearing, and possibly Tuesday to continue working bills if we don't get our work done on Monday. But currently we are scheduled to meet Monday and Tuesday. With that, then, thank you, and the meeting is adjourned.